topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good morning, Tampa. Welcome to another Ask the Expert show where we bring you the top experts in the field of legal, health, financial, and home improvement. This is, gosh, I can't believe I'm saying this. This is the last Monday in June. I cannot believe we're almost halfway through the year already. But last Monday of the month means Attorney Debbie Baker doing our estate planning show. And I want to remind everybody, listen, this is one of the most wonderful estate planning attorneys, not just in Tampa, but throughout Florida. And we want you to contact her when it comes to wills, probate, trust, estate planning, and make sure you tell her you heard on our show, Ask the Experts. Good morning, Debbie.
So how are you? I'm good. What was I going to say? It's not only the last Monday of the month, it is the last day of June, which means for all intents and purposes, we are halfway through the year, which is pretty ridiculous.
That's right. This is the last day of June, not just the last Monday. It's amazing.
I kept thinking tomorrow was June 31st, but there is no June 31st. So today is the last thing. Yeah,
that's right. Well, I always look so forward to the show because I got to tell you, I love the way you explain things. And I think some of it probably comes from your days in coaching. And you've got such a fabulous story. But today, listen, we could spend 30 minutes just on how you became an attorney, but I know there's so many things that we want to educate people about when it comes to estate planning. So first of all, tell people though about your law firm.
Okay. So my law firm is located in Tampa. I am licensed in the entire state of Florida. And so I can do work outside of the metropolitan area of Tampa. I do wills, trusts, kind of like Steve said. I do probate, which oftentimes can be avoided with proper planning. And I've started doing elder law for asset protection for people. I've come to really, over the last couple of years, really seen how valuable that can be. People do not have to impoverish themselves in order to get government benefits, should they qualify. And I'm a solopreneur who works with a covey of other attorneys, either in other specialties or in the field of estate planning and probate, who handle different kind of cases than I might. And generally, I can solve pretty much every problem, or certainly find somebody who can.
Debbie, we got a email the other day. They saw where your show's going to be coming up, and they wanted to know, how do you qualify for Medicaid?
Okay, so Medicaid is government benefits, which are asset-based and income-based, at least in Florida. I think there are other states where that may not be the case. So right now, the federal guideline for income is anyone if you are earning $2,901 or less, you qualify for income. You can shelter income over that amount, but 29, I'd love to know how they came up with 2901, but 2901 or less. And then
a year,
a month for income.
A month, okay.
A month. Good. So for assets, you're allowed $2,000. which is very, very little. And there are ways to shelter that very ethically, very legally, with high integrity, such that if there are government benefits available, a person can get them. And Medicaid is designed to help people who need to go into assisted living or nursing homes. They and maintain their dignity. So you can always keep a home. A homestead is always, it's never available to Medicaid, so it doesn't count toward your assets. So assets would be bank accounts, IRAs, retirement accounts, all that. But so Medicaid is income and asset based in Florida. And if you think you need it, because you've got, right now I've got one client who's working with her uncle. He's still very young. He's 73, but he's diabetic and he's pretty much blind. He cannot live on his own anymore. So we're looking at how do we get him government benefits to pay a differential between what he earns and what a assisted living facility would cost. So that's Medicaid. Medicare is something you get when you're 65 years old, regardless of your health, or you can get earlier if you're disabled and can't work, and Medicare can kick in at a younger age. But most people get Medicare when they're 65, and it doesn't matter if they're still working or anything else. They're eligible. They're eligible for Medicare. So, Steve-O, I don't know how old you are, but let's just say you're 65, and you're going to work. Close. Okay. You're going to work until your maximum Social Security age, which is 70. If you're working for somebody who's paying for your health insurance, you don't have to take Medicare. It's if you weren't working, that Medicare would kick your health, that Medicare health insurance would kick in when you're 65. And that's in a very small nutshell.
I think you're one of the most incredible estate planning attorneys. I really mean that. What do you think is one of the most important things a person can do when it comes to estate planning?
Get it done. The most important things they can do is get it done. People don't do it because they don't think they have anything, they don't have enough, or they're waiting for or they think they'll die before they think they'll die as soon as they do it, or they're going to let their family do it. So the most important thing about estate planning to know is that if you love your family, you want to do it, because the grief they will experience if you don't is multiplied financially many times more than it would be if you'd done it. And emotionally, when somebody dies, somebody you love dies, the only thing you should need to do at all is grieve. But certainly the only thing you should need to do for the first 6 months or a year is grieve. If people have taken care of things, then you can just be with the sadness and take care of the rest of it at some later date. There's nothing urgent. It becomes urgent if somebody's got bank accounts and you can't access them because, so in your case, Steve, Sophia meant to name you the beneficiary on all of her accounts, and you kept bugging her, have you done it? Have you done it? Have you done it? And she kept saying, human being, go away, leave me alone, go away, leave me alone, go away, leave me alone. Or as I've heard somebody says, I'll die before I beat you out of it. And then you die. Well, you haven't beat her out of it. Then she dies. She hasn't beat you out of it, but you're going to have to pay an attorney thousands of dollars to get whatever she could have left you with a simple beneficiary designation. Or you've both been married before, you have children from both marriages, and one of you dies and you haven't done anything, and your children are 100% entitled to anything you had because you didn't beneficiary designated. So you want to get it done. Find somebody you trust, find somebody to talk to, get the real thing about what it costs, find out what you can do minimally to protect yourself and your family, and get it done.
I am so surprised the amount of celebrities who never did a will. And I just read about a celebrity that passed away last week. I can't remember their name, but the first thing they said is they never wrote out a will. How do you do that? Because most celebrities have a pretty big nest egg. How do you not just have a simple will?
Well, how do you not?
Not.
You not have one, I would say, because you don't listen to people who know better because you think you do. If you're young, you don't listen to people who know better because you're young, and
Right.
and young is defined however you define young. You don't listen to people because you haven't gotten married yet, you haven't had your first child, you haven't bought your first home, and you only have a certain amount of money in the bank, and I think a lot of it's just pure ignorance, because I've run into a lot of couples who think, gee, we've lived in this house together for 20 years, so I must own half of it, even though you know that your name isn't on the deed. Or I must own half of it because we signed a note together to remodel the house, and I was sure that transferred title of the house to me. So people do it because they don't listen to their advisors. It may be that they've got advisors telling them all the time, you have to do it. Or they just, don't think about it. I had my first financial advisor, or the first stockbroker I ever worked with. He worked with athletes, but he wouldn't work with any athlete who wouldn't give him the money to invest. Who would nickel and dime, he would be reluctant. They had to be willing to invest and wait for the long haul. They did promise to take a part of their bonuses or whatever and invest it, because they weren't going to be able to play professional baseball, basketball, hockey, for a long time. But most and people don't think they have the time. They don't think they have the time to do it, because it's a break from your routine. So anything new that you want to do is a break from your routine, and it's easy to put off getting it done. I have a niece and nephew who've been getting it done for the last 5 years, because their oldest one is 5, and they haven't done it yet.
Wow.
And they've got a 5-year-old.
That's a family member.
Yeah. Well, yeah. They've got a 5-year-old and a 2-year-old. Oh, and my niece keeps saying, we're going to do it, Deb. We're going to do it, reminding me every 30 days. But,
wow.
Yeah.
So as an attorney, you assist people in making the proper assessments of their estate and making the best plan for themselves. How do you go about doing that?
I ask a lot of questions. When I was a coach, I asked a lot of questions. I was known for asking difficult questions, even though you couldn't give me a wrong answer. So recently, I have a couple, I guess they're in their early 40s, I guess. They've been married for 10 years. They're not sure if they're going to have children or not. Well, whatever their decision is, that's fine. But I asked, do you want to put something in your documents whenever we do them that applies to what they call afterborn children? So they didn't exist now. They weren't gestating now, but who knows if you might change your mind. And they said no, which is fine. I mean, they didn't want to plan for it. But that was a difficult question for me to ask. And I actually wonder whether I offended either one of them by asking the question. And it's a really appropriate thing to ask, just because. So I ask a lot of questions. People have to think. Got a client right now. She was going to name one of her children to fill all the roles. And in the conversation we had last Friday, she said, I'm not sure if that child will do what I want when the time comes. I said, well, then don't appoint them. She said, oh my gosh. Well, what do I do? I said, well, you need to talk to that child to see if they'll do what you want. Or you already said your other child will likely do what you want, and maybe you need to appoint them. So those are the difficult questions. To get past the emotional, I should appoint my eldest, I should appoint my youngest, whatever.
What do you do in a case where, let's just say you're appointing a power of attorney, And from what I understand, it really causes the problems, the ones that aren't named supposedly. So I think you can appoint two or three people, right? But it still comes down to who makes that final decision. How do you work around that?
Well, for powers of attorney, which is about financial decisions, I never recommend you appoint co-people,
Okay.
because if they don't agree, then nothing gets made. Or even worse, which happened to me once, this woman appointed her children as co-powers of attorney, and they didn't agree, but she didn't say that, like, Susan had, if Susan disagreed with Joe, there was no activity. So she didn't say anything, and both of them made decisions for her, which were 180 degrees different. So the kids wound up not talking to each other because the one thought the other was trying to defraud their parent. So I never recommend co's. Successors, yes. Appoint you and then Sophia, but not you and Sophia. For healthcare surrogates, I've come to believe when people are older, 70s, 80s, in ill health, it may pay to appoint co's as long as the document says either one of these can make a decision and it's binding on the others. Because otherwise health decisions could get held up. Versus successors, which means you would have to decline or resign before Sophia could take precedence. Or the doctor would have to verify that you were not available. I think where you might be living in emergent situations, that's not a good idea. I have one with 3 children. I said, if you want to do co's, it's got to be the majority, two against one. But she decided to just go one at a time. But not co-power, not co-anything except possibly healthcare surrogates. Because if they don't agree, then the legal system is stymied to help you.
We talked about on past shows a living will,
Mm-hmm.
and you've explained what a living will is. What would you say um, some of the things people don't know about a living will?
Well, for one, people confuse a living will with a last will and testament, because people still call me and say I have a living will. But the living will is the document that is used for end of life decision making. And you've given somebody the right, if you don't have capacity, to turn off life support or leave it on. It's all your choice. But you've given somebody a piece of paper and the right, which is a pretty heavy responsibility, to hold up to a doctor and say, this is what my mom wanted. I don't care what the rest of these people say. I don't care what you say. And it's all based upon a primary physician and a consulting physician saying there's no reasonable medical probability of recovery. My mom was dying. She'd have good days and she'd have not so good days, and then she'd have good days and not so good days. And my older brother pointed out to me that the good day she had today and the good day she had Wednesday, they weren't as high. The peak today was higher than the peak on Wednesday. So nobody was going to make her better. She wasn't going to recover from her cancer. There was no reason for life prolonging measures, tube feeding, surgery, antibiotics, dialysis. The idea was make her comfortable. So the living will is for the very end of life, when you're faced with this, and you've got to choose the person who will execute your wishes, whether they agree with them or not. They don't have to agree.
Yeah.
They don't have to agree about letting you die or keeping you alive. They just have to agree that they're going to honor your wishes. And the piece of paper is what gets held up to all those other people in your family or the doctors and say, this is what she wants. This is what we're doing. So that's the living will. That's the living will. End of life.
Well, I got to tell you, we've got about 4 minutes left. I want to know if can you explain what a medical power of attorney is? We've
Yeah,
never
we
discussed that on the show before, I don't think.
well, we call it a healthcare surrogate, same idea.
Okay.
So the medical power of attorney, the designation of healthcare surrogate is you give a person or people, generally one person at a time, the right to make medical decisions for you. You give them the right to speak to your doctors. You give them the right to look at your medical records, and you give them to make medical decisions for you and speak. So recently, I had a friend whose mom was in the hospital, and the friend is the healthcare surrogate for her mom, and her mom was not in a condition. Her mom has pneumonia. Mom was not in a condition to ask a lot of questions. If her daughter had not been there to ask the questions, the mom might still be in the hospital. Daughter was there to say, this is what I want. This is what we need. We need it now. You're not giving it to us. We're not happy. We're going to talk to people, and we're taking her home because she's stable. So your healthcare surrogate is the one who's intimately involved with your healthcare. And as long as that person has capacity, so as long as this woman's mom could say to the doctor or PA or whatever, I want this or I don't want this, she rules. Had that woman gone into a coma or been unconscious, that healthcare surrogate is there to protect her rights and make decisions. That's what the medical power of attorney does, healthcare surrogate does.
What do you say to a family member? I'm sure this has happened to you many times, who want to contest a will.
Find another attorney. And for one, that's the first thing. And for them to know that, for them to prove that a will was signed with undue influence, was executed with undue influence, you're sitting at your father's side. Of course, you're going to leave everything to me. And your brother, who you adore, but you're mad at him because he made you do your estate planning, isn't there. So you say to your dad, you're going to do, and he just does it. For your brother to prove that you exerted undue influence is his job. He has to prove it. So it's very expensive, and it's court. I tell people it's not worth it, in my opinion. Emotionally, it's not worth it. I don't even know it doesn't even matter to me how much is at stake, unless you have a clear case about undue influence by a family member or a caregiver. I mean, it certainly happens. There's no doubt it happens. I'm more on the side of what's it going to cost you emotionally? What are you willing to give up emotionally in terms of what it does to your family and your relationship with your loved ones while you're fighting this battle, which you have to prove. So, but the first thing I would say is I don't do it, and I can find somebody for you who will contest the will.
I'm actually not surprised that you said that. Debbie, tell people this is really important. And for those of you who say, well, I've got a will, you should have that wills. Have Debbie look at that will, because so many things change over the years. And,
Yeah.
And also tell them that you heard about her on the Ask the Expert show. How do people reach you, Debbie?
Well, if you're on TV, you can see my phone number is
Right.
It's 813-586-1332, 813-586-1332. The email address is debbaker@londonbakerlaw. I would tell you, if you have a plan and you haven't looked at it in 3 years, you want to look at it because things have changed. Yeah, and you just want to look at it just for safety.
Well, the show has become so important that we replay the show 3 times additionally a month, and we always do it on Monday. And I got to tell you, if you missed some of the show today, you can go to iHeart, you can go to Spotify, you can go to YouTube under Ask the Experts Tampa, and you can replay all of her shows. Debbie, thank you so much. Have a great 4th of July. We are so blessed to have you.
Have a great. See you, Rebel.
I love that
Have
smile
a great one.
too.
Bye.
That's attorney Debbie Baker. We're going to go to break. When we come back, we have more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.